Income Tax Law, H.R.1, December 2017. The new Federal Personal Income Tax Law, H.R.1, that was just enacted into law by Congress in December 2017, and already made effective as of January 1, 2018, has the immediate legal effect of completely disemboweling and destroying the I.R.'s current personal income tax collection and enforcement practices and operations, by removing them entirely and completely from all legitimate constitutional authority to act to enforce the direct taxation of income under the 16th Amendment, as practiced for the last 60 years. Strips the Federal Department of Justice naked in the courtroom of all of its illegitimate constitutional arguments that have been made in the courtroom for the last 60 years, to sustain the federal courts, both district and tax courts, erroneous enforcement of a direct and unapportioned tax upon the income of we the American people under alleged authority of the 16th Amendment, and completely exposes the federal judiciary's unlawful enforcement of the federal personal income tax under the 16th Amendment over the last 60 years of American history, as nothing but a complete and total judicially committed fraud. That plainly and clearly can now be seen as the true judicial conspiracy of sedition that it is, to undermine and remove the constitutional limitations placed upon the federal taxing powers, in order to enforce the unconstitutionally direct taxation of the labors and work, wages and salaries, of the American people, in order to fund, not the legitimate operation of the government, but the constitutionally unauthorized progressive, liberal, Fabian, socialist programs affecting the distribution of wealth that have been used by the politicians to create the welfare-based, class warfare system of taxation that has resulted in the divisive destruction of America, its people's freedom, liberty, private property, and equal rights. By expanding the judicial authority beyond that which is constitutionally authorized, to enable the federal judiciary to constitutionally usurp the legislative authority of the Congress, through the judicial enforcement of only the perverted judicial Fabian opinions they issue, in place of the actual written constitutional tax law that is authorized and exists. What? You may say, that's crazy. What the hell are you talking about? It's the same tax it's always been. There's nothing new in the law that could do that. Yeah, that's right, it's the same income tax law that it has always been, and now they have admitted it on the congressional record, and their world is about to change, well, actually implode. Congress has no idea of what they have done, or of the true extent or size of the catastrophe within the tax enforcement system, that they have wrought with the new income tax law, and few Americans, if any, have realized it yet, but any honest lawyer will tell you, after reading this, that everything you are about to read, and have read up to this point in this article, is irrefutably true. Fact: for the last 60 years the IRS has been issuing income tax collection correspondence to Americans asserting that American citizens owe the payment of an income tax on their work, because of the adoption of the 16th Amendment. This claim to legal authority is all over their website, it is in their frivolous arguments publications, where they repeatedly assert the income taxing authority under the 16th Amendment, and label as frivolous any reference made to the limitations on the taxing powers imposed under Article I of the Constitution, and it is in the pleadings made on the record of the court by the United States as a plaintiff, in every tax case prosecuted in the federal courts in the last 30 years. Fact: the Department of Justice attorneys argue in every single income tax case prosecuted in the federal courts, that the income tax is owed by the individual defendant as a function of the 16th Amendment alone, without use or need of any applicability of the authorized indirect Article I-8, impost, duty and excise taxing powers. Fact: for the last 60 years the federal courts have been wrongfully allowing and upholding the constitutionally prohibited, and therefore unconstitutional, direct taxation of the alleged gross income of the American people, created as a function of all of their labors and work, as a direct tax without apportionment, under alleged authority conferred under the 16th Amendment to tax income, from whatever source derived, without apportionment, and without regard to any census or enumeration. Fact: the 16th Amendment has no enabling enforcement clause in it, that would constitutionally authorizes the U.S. Congress to write any law to enforce any power alleged newly created or authorized under authority of the amendment alone. Fact: there are amendments to the Constitution, both before and after the 16th Amendment, that do have and clearly contain an enabling enforcement clause within them, irrefutably proving the absence within the amendment, of such alleged grant of any new enforceable power, is intentional. Fact: in assessing the legal effect of the 16th Amendment, the Supreme Court plainly said in 1916 that the 16th Amendment conferred no new power of taxation. The provisions of the 16th Amendment conferred no new power of taxation but simply prohibited the previous complete and plenary power of income taxation possessed by Congress from the beginning from being taken out of the category of indirect taxation to which it inherently belonged. Stanton v. Baltic Mining Co., 240 U.S. 103, 112-13, 1916. Fact: the Article I-8, Clause 1, authorities to tax only indirectly, by uniform impost, duty and excise, do not reach the labors of the American people with legal effect. This is why the federal government has argued for 60 years that the 16th Amendment was the sole basis for the enforcement of the income tax imposed by Section 1 of Title 26 United States Code. Title 26 is also called the IRC. The new income tax law enacted under H.R.1 is not the 16th Amendment at all, but relies solely on Article I-8, Clause 1 of the Constitution of the United States for its authority. Oh. You mean it isn't the 16th Amendment, and that claim of constitutional authority under Amendment 16 as legal foundation to sustain the imposition and enforcement of the personal income tax, can never be made by the IRS, or in court by the United States attorneys, again, ever. In neither civil, nor criminal, tax prosecutions. Finally, the true and correct constitutional authority for the federal personal income tax is plainly and clearly specified in the law, on the Congressional House record, as being established under only Article I-8, Clause 1 of the U.S. Constitution, which contains only the grant of the required constitutional authority to tax, indirectly, by impost, duty and excise, which powers, by law, Title 15 U.S.C. 17, do not lawfully reach the labors or income of the American people with force of law. Though the proper and lawful invocation and enforcement upon individual persons of only the granted indirect taxing powers. The new income tax law, H.R.1, by completely removing the 16th Amendment as an arguable constitutional basis and legal foundation, or as the applicable constitutional authority that is eligible as the constitutional authority for the imposition, withholding, collection, and enforcement of the personal income tax in the federal courts as a direct tax, completely strips the IRS, the DOJ, and the federal judiciary of all of their lawful ability to legally enforce on American citizens after January 1, 2018, the federal personal income tax in the federal courts as it has been practiced since 1945. It's over. The IRS, the DOJ, the federal judiciary are all eviscerated. The monstrous income tax fraud perpetrated by the federal courts on the American people is fully exposed now, naked to the world, and the behavior and opinions of the federal judiciary are exposed as nothing but the treasonous sedition they have always been, i.e., communistic and not constitutional. Repugnant, disgusting, corrupted, polluted, perverted, ultra-vires judicial behavior and opinions, all committed for 60 years outside of the granted constitutional authority that exists for the court to lawfully act under, is all exposed. Naked to the world as the emperor wears no clothes. It has all been conspiratorial judicial theft. Nothing more, and nothing less. The judicial crimes of the last 60 years, fraudulently perpetrated on the American people by the federal judiciary in the name of tax has all been pure unlawful and wrongful conversion of the constitutionally protected private property of we the people, under color of law, under color of office, and in the name of tax only, for there is no law because none is authorized, and there is no enforceable direct tax or taxing power conferred under the 16th Amendment, because no such power is constitutionally made enforceable against the individual person 3, as opposed to one of the several states 3 Article 1, 2, Clause 3, representatives and direct taxes shall be apportioned amongst the several states which may be included within this union. All American citizens, in all 50 states, are all now exempt by constitutional law from any required payment or withholding of the federal personal income tax from their paycheck, earned at their place of employment in one of the 50 states, and everyone should therefore now claim exempt on their W-4, as provided in law thereupon, under the Supremacy Clause exemption from withholding, that is made at Title 26 U.S.C., IRC, 3402, N, for informed employees to claim. Google it, H.R.1 Constitutional Authority Statement. See for yourself. Without the use of the 16th Amendment to erroneously allege a direct tax on income that is owed by all persons, there can be no lawful enforcement of the personal income tax on the income of the American people, by any department, agency, service, or any other group of men that exist within the federal government, like the IRS, the DOJ, the federal judiciary, or even the United States of America, as a plaintiff in the courts, without there first being the clear applicability of some impost, duty, or excise tax to measure, that lawfully and properly taxes the underlying taxable, business, commodity, or trade-based, activity from which the income is derived. So, if there is no impost, duty, or excise tax that exists in the written law of the United States Code, the written laws, that applies to the underlying taxable activity, resulting in taxable income, then there is no amount of gross income to measure as tax. And, since there is no impost, duty, or excise tax that exists in the written law of the United States Code, the written laws, that reaches either the wages or salary of the American people, earned by right, as those terms, wages and salary, are not included in IRC 61 defining the sources of gross income constituting taxable income of an American citizen, but the terms are specifically included in IRC 1441, b, wherever wages or salary are earned by the non-resident alien person that is identified in law under IRC 1441, a. And, since it is only the foreign person who is made subject under the provisions of IRC 7701, a. 16, to the collection of the federal personal income tax imposed in the Code sections of Subtitle A, Chapters 1 to 6, of Title 26, which is where the original 1913 income tax laws are found in today's law. Subtitle A is the body of law that was enacted by Congress in 1913 as the Federal Personal Income Tax Law, enacted under the original income tax legislation of the Underwood-Simmons Tariff Act of October 3, 1913, then it has now become impossible, under the new H.R.1 income tax law, under Article I-8, authorities, for any party or person to lawfully withhold or collect any federal income tax from the payments made to an informed American citizen in one of the 50 states. Oh, by the way, a tariff, as enacted within the Underwood-Simmons Tariff Act of October 3, 1913, is one form of an impost which taxing power, when exercised in the 50 states, is limited in constitutional operation to the taxation of only foreign persons and imported foreign goods, commodities, and other taxable articles of commerce. An impost, in the form of an enacted tariff, has no internal application to the domestic activity of American citizens conducted by right within the 50 states, without any involvement with foreign goods or foreign persons. Thus, the new federal personal income tax law, H.R.1, that was just enacted into law by Congress in December 2017, and already made effective as of January 1, 2018, has the immediate legal effect of completely disemboweling and destroying the I.R.S. current personal income tax collection and enforcement practices and operations, by removing them entirely and completely from all legitimate constitutional authority to act to enforce the direct taxation of income under the 16th Amendment, as practiced for the last 60 years, exposing 60 years of IRS theft and unlawful conversion by fraud. Strips the Federal Department of Justice naked in the courtroom of all of its illegitimate constitutional arguments that have been made in the courtroom for the last 60 years, to sustain the federal courts, both district and tax courts, erroneous enforcement of a direct and unapportioned tax upon the income of we the American people under alleged authority of the 16th Amendment, exposing 60 years of DOJ fraud and stupidity, and completely exposes the federal judiciary's unlawful enforcement of the federal personal income tax under the 16th Amendment over the last 60 years of American history, as nothing but a complete and total judicially committed fraud that plainly and clearly can now be seen as the true judicial conspiracy of sedition that it is, to undermine and remove the constitutional limitations placed upon the federal taxing powers, in order to enforce the unconstitutionally direct taxation of the labors and work, wages and salaries, of the American people, in order to fund, not the legitimate operation of the government, but the constitutionally unauthorized progressive, liberal, Fabian, socialist programs affecting the redistribution of wealth that are used to create the welfare class and class warfare systems that are resulting in the destruction of America, freedom, liberty, private property, and equal rights. By expanding the judicial authority beyond that which is authorized, to enable the federal judiciary to constitutionally usurp the legislative authority of the Congress, through the judicial enforcement of only the perverted judicial Fabian opinions, in place of the actual written constitutional tax law that exists. Exposing 60 years of judicial fraud, error, and arrogance. And now you know that not only is this not crazy, it is all irrefutably true. Oh yeah, by the way, it is the second plank of the Communist Manifesto that calls for the graduated and communistic taxation of a population that is kept divided by the different classes of the population defined in the non-uniform tax law by the creation of the different tax brackets established therein, with different rates of tax for each bracket as under the communistic system of unconstitutional taxation that we suffer under today, for the last 72 years since 1945, rather than the system of uniformity in taxation that is constitutionally required of both the authorized direct and indirect taxation of we the people in America and our activities. That second plank of the Communist Manifesto explicitly states a heavy progressive or graduated income tax. So, now you know where the income tax enforcement operations of the IRS, the DOJ, and federal judiciary really came from, for the last 60 years, because it isn't Article I of the Constitution of the United States of America, or the 16th Amendment. Our government, and especially the federal judiciary, stand condemned by their own ignorance and arrogance, and sedition. By its own congressional admission, now made in the written formal congressional record of the United States of America, they are nothing but as guilty as sin itself. And now, there is only one path left by which they may escape to find their way back to justice and righteousness: repent. Valid until expressly prohibited by law. Submitted with respect for the law this ____ day of February, A.D.2018.